What happens if we leave out a debt when filing for bankruptcy? Leaving out a debt when filing for bankruptcy can have different consequences depending on the type of bankruptcy you're filing, Chapter 7 or Chapter 13, why the debt was omitted, and whether it was intentional or accidental. Here's a breakdown of what might happen. If you accidentally leave out a debt in Chapter 7, if your case is a no-asset case, which means there's no money to distribute to creditors, and the debt would have been dischargeable, courts often allow the debt to be discharged anyway, even if it wasn't listed, as long as the omission wasn't intentional and the creditor wasn't harmed. If you leave out a debt in Chapter 13, your omitted debt may not be discharged unless you amend your schedules and notify the creditor in time for them to file a claim. If a creditor never receives notice, they can argue the debt is not dischargeable. We always remind clients that it's important to add personal loans from friends or family, lawsuits that are still pending, or old utility and medical bills. Remember, it is important if you left out a debt that you first amend your schedules, second, that you notify the creditor, and third, if discovered after the discharge was entered, that you notify your attorney so your attorney can take proper steps to resolve the debt. Remember, this is always important to be thorough and honest. It's better to list a debt you're unsure about than to risk forgetting it. When you need to have experienced bankruptcy attorneys on your side, call our office today for a free debt relief consultation. Hi, my name is attorney Sacca with Bononi Company. If you have any questions regarding the topics covered in this video or any other legal questions, please don't hesitate to give us a call at 724-832-2499.